have a second, please be seated.
Good afternoon. Well, not quite afternoon yet. The next matter on our list today is docket 22, P1155, Canal Realty Trust versus Alexandria Real Estate Equities, and another. Mr. Fleming?
Good morning, Your Honors.
Morning.
Wayne Dennison. I'm here on behalf of the appellant, plaintiff below, CANAL Realty. CANAL Realty has appealed from the judgment dismissing in its entirety its 5-count complaint and from an award of more than $193,000 in attorney's fees relative to a single motion.
Big money case.
It is, in many aspects, a big money case. That said, quite frankly, Judge Barry Smith below indicates in his decision on page 6, footnote 7, as the court need not look beyond the allegations in the complaint and the documents attached thereto to resolve this motion, this dispute. It's a dispute over the nearly 1,000 pages of additional materials that were submitted relative to a motion to dismiss. This dispute is of no consequence. So Judge Barry Smith, I think, acknowledges there that he very much was able to resolve this case on the pleadings without reflecting on the other materials. I'll give you a little bit of background, and then CANAL Realty Trust, well, the trustees at CANAL Realty Trust ran a plumbing supply company.
We got it. For 70 years in Cambridge, realized that the land they're sitting on is more valuable than the company itself. A lot was happening in that area of Cambridge by way of farmer and other things going on. Sitting on gold mine.
Right, okay, you do have it. So the issue here deals with not the initial purchase price of the property. There's no dispute.
That was paid?
Yes.
Yeah.
The initial purchase price was paid. There's no dispute there. It deals with additional purchase price, an additional purchase price that was not guaranteed. And I'm not even going to suggest that it was guaranteed, nor did I intend to suggest below that it was guaranteed.
Let me ask you this question.
Certainly.
What was the value of getting the increased zoning? What was the value to Canal?
To Canal, if under the purchase and sale agreement, if there isn't a linkage fee.
No, I'm sorry. Let me put my question a bit
Sure.
differently. Why was that important to the parties? Why did they want the density zoning increase? How was that going to help them financially?
Oh, so if you're on the developer side, if you can get greater density, you're going to likely be able to derive more rent from these properties. And this has a very long-term tail in terms of your ability to derive rental income that is extraordinary in terms of its scope. I cannot tell you as I stand here today what that number, what it's worth, but the parties put in a provision in the PSA that said that if you did the formulae, the amount of additional purchase price before linkage that would have been due just to Canal was north of $55 million. Then you have to deal with a linkage issue. And quite frankly, the court below dealt with the linkage issue, but only dealt with it in one way.
Well, it dealt with it in the way that it was defined in the PSA, right?
The judge needs to have made a determination as a matter of law that more than $55 million in payments promised are in fact linkage. And I don't know how you can possibly do that.
Didn't he kind of do that? Didn't he say that even if you just did the substation piece alone, that would have really covered the $55 million?
I don't think the substation alone covers the 55, but in any event.
Did he say that?
Yeah.
I thought I read a footnote or something to that effect.
But in every instance, quite frankly, relative to those determinations, the judge says he did it on the record. There's no basis on the record to make the determination that is a matter of law that this is linkage. But there's a broader problem here, Your Honors, and the broader problem, quite frankly, is reflected in a single sentence in the judge's decision below. As the trustee's claims of breach of the implied covenant of good faith and fair dealing, count 2, breach of fiduciary duty, count 3, and breach of the guarantee depend on the trust's entitlement to the additional purchase price, the defendant's motion to dismiss those claims is allowed. There is no basis on this record or on any record to dismiss the breach of fiduciary duty claim.
So, all right, so let's talk about, is there a fiduciary duty?
It is our contention that there is, in fact, a fiduciary duty.
What's your best case for it? Baker?
Yeah, but the short answer on this, Your Honor, is these are fact-dependent inquiries.
I get it, but that doesn't mean that they can't be decided on summary judgment. The cases tell us they can still be decided on summary judgment.
This isn't summary judgment.
On a motion to dismiss.
Well, but most of the cases that do get decided adversely, if they get decided as a matter of law, they get decided on summary judgment on a full record. This is a case with no record whatsoever. All we have in this record is relatively unsophisticated people dealing with the most sophisticated life sciences developer in the world. And we sent them off to negotiate. We did not have input on that negotiation. They knew that our additional purchase price would be dependent in large part on their negotiation, and all of the facts here are sufficient to at least raise the inference that there is a breach of fiduciary duty here.
Let's say the motion to dismiss had raised the issue of the existence of a duty, and you moved to amend your complaint. What additional factual allegations would you have put in the amended complaint?
There's an allegation by the plaintiffs that we were required to plead that that CANAL had their mutual assent to a fiduciary duty. That allegation would certainly have been added. I think the issue, when you look at it, if you look at the purchase and sale agreement, there's a provision, paragraph 42, that expressly disclaims a joint venture. It expressly disclaims a joint venture. If these parties wanted to disclaim a fiduciary duty obligation, they could have done that easily. There's already a provision in the contract that deals with a similar issue. You're talking about, they had superior knowledge. They were doing all the negotiation. They were, in fact, spending our money at least up to the first $55 million.
So some of the cases seem to suggest that that has to be, I don't know, I'm going to say solely, but maybe solely is not in there. That's what my question, essentially, for the benefit of CANAL. I mean, in this case, didn't they both mutually have something to gain with the additional purchase price?
Well, not with the additional purchase price, but with the additional zoning density, they both would have had something to gain.
Right.
But
doesn't Alexandria have to pay $10 million out of pocket as things stand right now?
They do. The first 50.
How is it in their best interest to go that route?
I'm sorry?
How is it in their best interest, Alexandria's best interest, to go that route if they're the ones who are going to end up having to pay $10 million out of pocket?
Well, $10 million, given the scope of this issue, is not an extraordinary spend. And the first 55, they got free because they would have otherwise had to pay.
They're paying it to, they'd be paying it to someone, I guess. I'm just not seeing what motive they would have had to do this.
Well, that's a great question, Your Honor, because the motive issue becomes very important because we never got any discovery on it. Two of the things that happened here are Eversource, NSTAR, whatever you want to call it, and Boston Properties, each got multi-million-dollar benefits from what they were promised by Alexandria.
Now, was some of that foreseeable? That there was going to absolutely be monies that were going to be paid in order to kind of soften up the resistance so that they could get the increases on?
Clearly, the parties foresaw that there would be some linkage fees, or at least the potential for linkage fees. But if you look at the contract, the scope of those linkage fees as contemplated in the contract, and I'm not saying it was a cap or anything of that nature, but if you look at the examples in the contract, the linkage fees were at $1 million, $4 million, and $10 million as the within the reasonable contemplation of the parties.
Who drafted the contract?
The parties. I don't think you can construe the contract against either party.
Okay.
I mean, the contract also contemplates that the linkage fees would exceed the additional purchase price,
Oh,
right?
it certainly
So,
could.
So if that's the case, then how much relevance do we give to those examples?
Well, because I think there's you look at the examples, and there's a possibility that the linkage fee would exceed because they might not get very much more density. I mean, whether you're going to have to pay linkage is going to be based on, is there additional zoning density? You get to the 55 million because there's a formula relative to the value of the additional zoning density. You might never have to pay you might never have to pay the additional purchase price either because you didn't get any more zoning density or you just got a little. That contemplation doesn't, I think the notion that there's a possibility you would not have to pay, okay, there's a real possibility you would have to pay, and there's 3 separate examples in the contract that at least have to be considered in terms of the reasonable expectation of the parties.
So are we still talking about fiduciary duty?
Okay.
Let's talk about fiduciary duty. What are the specific paragraphs in the complaint that you rely on to support breach of any fiduciary duty? I see paragraphs 45, 46, and 55. Are there any other paragraphs that you're relying on for support of breach?
Yeah, let me get you specifics. With respect to disparity in knowledge and experience, that element,
No, not the existence of the duty, the breach of a duty. Let's assume there's a fiduciary duty, or at least that needs more factual development. So the allegations relating to breach I saw were 45, 46, and 55. Are there any other allegations?
Those are the principal allegations of the complaint relative to breach, but in 43, 44, 79,
44, 79.
32, 39, 40, 45, 47, 55, 78, and 79, 23, 31, I'm sorry, paragraphs 38 and 78.
Okay, can I ask it differently? Can you point to a concrete, non-speculatory allegation in the complaint that shows that they breached a fiduciary duty?
That we directly allege that they breached a fiduciary duty.
But there has to be some factual heft to the allegation. So, I mean, it's not enough just to come in and plead, well, these payments were excessive and therefore there was a breach. So I'm looking for something specific in the complaint that shows a breach.
We have pointed, for instance, to the notion that the housing fee, which they charged us $7.2 million against, they would have had to pay $3.2 million.
That's fair. What about in relation to Eversource, the Eversource substation?
The Eversource substation is activity that's not even occurring on the property at issue. These are activities that are remote from the property.
It was agreed to obtain the zoning approval, right?
There's no evidence in the record of that. All we know is that it was offered.
And isn't that enough to bring it within the language of the complaint? The language of the PNS?
You can't make the judgment that it's linkage unless unless you know that it goes to a mitigation.
Well, so I had a question about that. That seems to be how the judge read it. But, I mean, it reads differently, doesn't it? It says, any other cash payments, comma, and the cost of satisfying any mitigation obligations, comma, required by or offered to induce the adoption or issuance. So why is the any other cash payments tied to showing that it was a mitigation obligation?
The cash payments are either intended to link to the ability to get these permits, or they're not.
Yeah, I agree, that's linked, but it doesn't have to be the cost of satisfying any mitigation. So if you take out that phrase, then it would read, any other cash payments required by or offered to induce the adoption or issuance of any amendment or permit.
The language of the court below, and I'm sorry, Your Honor, I have your point.
No, that's-
The language of the court below makes multiple factual findings. Alexandria intended its involvement. This induced the issuance of special permits. They served as mitigation for the parking issues. None of those are developed in this record. They are all statements that have been made by the defendant in defense of what they spent.
And so you don't think that they were related to you don't think there was a sufficient showing that they were related to the parking mitigation?
What I
Is that
think
what I hear
is
you
that
saying?
we should be able to get some discovery as to what these things were for, why they were made, what the relationship was between Boston Properties and NSTAR that resulted in Alexandria giving them benefits of $20, $30 million in activity. That's
Well, that's kind of I led with, what was the, that's why I led with, by getting the zoning, what was going to be the benefit? That helps me picture whether that was big money they were putting out for that or not. If they're going to get hundreds of millions in return, then that might not be a big figure.
Your Honor, again, that's the kind of stuff that you get in discovery, and we got no discovery at all. We were tossed out on our ear on the very first pleading, irrespective of the fact that I believe that we've alleged every appropriate element. By the way, breach of the covenant of good faith and fair dealing is a breach of contract. And so we don't think that the contract claim should have been dismissed. The breach of fiduciary duty claim should not have been dismissed. And to the extent that the court wants to reach this, and I don't think you have to, there has never been a reported case in Massachusetts where somebody got $193,000 based on one motion. Thank you very much.
Thank you, sir. Mr. Dennison?
Fleming, Your Honor.
I got it backwards. I apologize, Mr. Fleming. Can I ask you to pick up where your brother left off? What do you think about $193,000 worth of attorney fees on a motion to dismiss?
Well, this was well within Judge Barry Smith's wide discretion here. There's no dispute now, as the case stands before this court, that the rates were reasonable. The judge did the trust a favor by awarding us less than we thought we were entitled to. We haven't challenged that. The trust doesn't point to any of the tasks that we actually did that were supposedly unnecessary in this context. They're just saying that this one cost more than other motions to dismiss. That is not an abuse of discretion. Judge Barry Smith considered that. It doesn't show that he considered improper factors or made an error of law, or that it was, as the SJC said in Ross versus Ross, incommensurate with objective evaluation of the services rendered. This was a hard-fought motion. The trust was seeking at least $55 million. It was a significant victory to convince the court over strenuous opposition from Mr. Dennison and his colleagues to end the case now without the parties having to incur the additional fishing expedition that Mr. Dennison is asking for from this court today. So Judge Barry Smith was well within his authority, we think, in granting the reduction of the fee requests that we'd actually made. There's some argument in the briefs, I didn't hear Mr. Dennison make it this morning, that there was an obligation on the judge's part to hold a hearing. I think that's completely unsupported by either the rule or even the case that the trust cites, the Central Ceilings case. I mean, there this court actually affirmed a judge's award of fees not notwithstanding the failure to hold a hearing. And
Well familiar with central ceilings.
I recognize that, Your Honor. And as in central ceilings, there's been no identification of an argument or a point that would have been made at a hearing that wasn't fully made in the briefs. So we think that pursuant to Section 47 of the agreement, Judge Barry Smith did exactly what the agreement required, which is he looked at our request, he looked at it with a skeptical eye, he didn't grant everything we asked for, and under the abuse of discretion standard, there's no basis for this court to disturb that. Sorry, Your Honor.
So, no, thank you. So now let's turn to the argument with respect to the linkage.
Yes. So this was a complicated real estate transaction. The trust was represented throughout by sophisticated counsel at Mr. Dennison's firm, and they negotiated a lengthy written contract that expressly contemplates that linkage might exceed the additional purchase price. Mr. Dennison conceded that in front of the Superior Court. He conceded it this morning. Now, the trust did get something very valuable, Justice Desmond, as you said. They got $80 million in initial purchase price. They also got protection from the possibility that if linkage was higher than the additional purchase price, they wouldn't have to pay a dime of it. Alexandria has to pay the $65 million, $10 million more than the trust's own calculation of the additional purchase price. They're protected from that. They don't have to pay any of that. Now, they try to argue that there was some kind of obligation, whether contractual or fiduciary, not to negotiate what they call excessive linkage. Now, there's nothing in the agreement that gives the trust the ability to decide how much linkage is too much, nor is there any standard by which this court or the parties could have measured something like that. The parties could have negotiated a cap on linkage. They could have negotiated a minimum additional purchase price. They could have negotiated a higher initial purchase price. They didn't do any of that. The contract is very clear.
In the definition of linkage, are you relying on any other cash payments or the cost of satisfying any mitigation obligations?
So we rely on both, Your Honor.
Okay.
Judge Barry Smith only relied on mitigation and found he
Right.
didn't
So
have to think
mitigation obligations is not defined in the PNS, right?
Not by itself. No, that's true.
So how is that appropriate to resolve on a 12b6?
Well, I don't think there's any dispute as to, there's been no interpretive challenge brought to the meaning of mitigation obligations.
Well, I thought your opponent was arguing that they're not mitigation obligations related to this project. They're related to a separate project.
Well,
so wouldn't we need more factual development to determine what the parties meant by mitigation obligations?
No, I don't think so. First of all, again, there's no argument made that there's any ambiguity in the meaning of the words mitigation obligations, particularly mitigation obligations that are offered to induce the adoption or issuance of an amendment to the ordinance or a variance or a special permit. And on this point that you need to go outside the complaint to decide this, Judge Barry Smith correctly found you didn't have to. All you have to do is look at the exhibits that the trust filed with its complaint in the Superior Court. And attached to the complaint as Exhibit C is the Notice of Decision of the Planning Board, dated December 22nd, 2020, which says that our petition is granted subject to the following conditions and limitations. And then this is on page 147 of Volume 1 of the appendix. It says the permittee shall implement all commitments included in the letter of commitment from Alexandria dated March 2nd, 2020, and attached to this decision. And that letter is also attached to the complaint. It's page 154 of Volume 1 of the appendix, and it details the Eversource relocation and Alexandria's commitments. The complaint also attaches as exhibit.
So you say that answers the question that the monies went to the parking mitigation?
Yes.
Those attached documents?
Yes, that's right. And in addition to that decision, also Exhibit E to the complaint, E for Eric, has correspondence with the city manager, where the city manager notes that the private parties, now this isn't outside the complaint. I mean, we think the additional materials we provided are cognizable too, because they're public records. But you don't even have to look at those. If you look at the letters that they attach to the complaint, they show the private parties investigated all the available options to relocate the substation from Fulkerson Street to somewhere else, and the ultimate resolution was that the somewhere else would be the site of the Blue Garage, owned by Boston Properties, and that in order to make it possible for Boston Properties tenants to park while the garage was demolished and alternative parking was being constructed, Alexandria had to provide a parking alternative.
So the substation had to be moved to resolve the residents' concerns with having two large commercial properties on adjacent parcels. Is that why it had to be moved?
That's correct. Not just the
so
residents.
I mean,
but
I
also-
could see if you read mitigation obligation broadly that it would encompass that, but where in the complaint or the attachments can we find that, or do we have to turn to the public record?
No, I think you can look at Exhibit C, which is page 147 of Volume 1, which talks about the conditions.
Right, those
that are
are just
subject-
the conditions, but how do we tie that to a mitigation obligation without looking at the public record?
Well, I think as a condition imposed to approval of this project, I think the only possible, the only non-conclusory outcome. There's nothing in the complaint that suggests that this was offered for some other reason or some other basis.
So
But if Your
what
Honor
does
thinks
any
you
other
need-
cash payments mean? Is that independent of and the cost of satisfying any mitigation obligations?
I think you could have, for instance, so there were some payments made to neighborhood associations in this case. I think those could
So
fall
the
under cash
Eversource-related
payments.
payments are not other cash payments?
Oh, we think they could be as well. We presented
okay.
both arguments. The Superior Court only relied on mitigation obligations, but we think they can be cash payments too, for certain. And whichever way you go, the outcome is the same. One thing, I don't want to be seen to be running away from the public record. I mean, the public record here is unequivocal. It is not as though one could draw alternative inferences from it. And the accusation of cherry picking is really quite remarkable because all of this material and everything else is on the City of Cambridge's website. It is just as accessible to the plaintiff as it is to us. And if there was anything anywhere suggesting that this deal could have been done without relocating the substation as was ultimately agreed in this multifaceted negotiation, they would have put it in front of you. They would have put it in front of Judge Barry Smith. They would have mentioned it this morning. It's all cognizable. We don't oppose that. But there is no suggestion that there was any other way to do this. The opposition from the residents, from the mayor, from the city councilors, from the planning board is unequivocal. It is manifest. And so I agree that
Was
Judge...
that all anticipated in the contract?
Certainly, it was anticipated there would be community opposition. Section 6B5 expressly talks about that. And that's the reason why it gives Alexandria the discretion and the permission to engage in a strategic process to try to get the increased density approved. I can read Your Honors the language. I think this is very relevant to the question. This is on page 41, carrying over to 42 of Volume 1 of the appendix. Seller acknowledges, so seller is the trust, seller acknowledges that buyer, Alexandria, may make strategic and tactical decisions regarding timing of applications and sequencing of efforts which take into account potential opposition and support from the community, neighbors, abutters, and elected and appointed officials, and such other factors as a prudent and sophisticated real estate developer would take into account in seeking to vest rights for development of greater density than is allowed under the current zoning ordinance. The parties absolutely anticipated this kind of a situation. What they didn't anticipate is this particular kind of situation. We didn't even know that Eversource was planning to build a substation on the adjoining lot. That only came out after we had tried twice to submit petitions that would have just developed our building and not done anything with the adjoining lot. And that's what we hope to do. The idea that we were somehow out to give away our money, $10 million more than we were obligated to potentially to pay the trust according to their own calculation, because we wanted to give the money for Eversource, is belied by, again, the public fact that's undisputed, which is we tried twice to get this deal done some other way. And it was rejected because it turned out that Eversource was planning to put a new substation on that land. Once that came up, and the community and political opposition to that became manifest, there was no way to get this done. And Justice Shin, I want to talk about the paragraphs in connection with the fiduciary duty claim that you drew our attention to, because I agree, those are the important ones. And they are very carefully phrased, and I think it's very important to look at how they're phrased. If you look at 55, which I think is the closest they come to alleging that the city would have approved rezoning or permits without the Eversource substation. They don't actually say that. What they say is the proposed development on the premises could have been achieved without relocating the Eversource substation. Mr. Dennison said something similar this morning. We could have built this building on this lot without moving the substation. That's true. We tried to do that. We filed two petitions that proposed that. Those were, but even on their terms, all this language says is that you could have physically built the building on those premises. But if you look at the public records, but even if you look at what was attached to the complaint, it's clear that they would not have been able to get approval to do it. And this allegation, carefully framed, does not actually say Cambridge would have approved it simply by building the building on the premises without moving the substation.
When you say I'm sorry, go ahead.
Oh, no, please.
When you say approved it, are we talking about the,
I'm using that as shorthand for rezoning, so for amending the zoning ordinance, which the city council had to do.
so was the
and
idea
then-
to get the rezoning at all costs?
Well, not at all costs. I mean,
Where do you draw the line?
well, so Alexandria would have had to make a business decision about that, right? And of course, this is all for Alexandria's account. The trust is protected from the cost of linkage. They don't have to pay a dime of it. So, if the city had come back and said, we want $1 billion, Alexandria would have had to make a business decision as to whether that was worthwhile, given how much rent they could have gotten for the increased density. I suspect they would not have paid $1 billion. But they made the business decision that $65 million, which they were Alexandria alone is liable for, was a good enough deal. Is that a good deal or not? Only my client can answer that question. But the point is, both the contract and common sense gives them the ability to make that determination. There's no cap on the amount of linkage they could pay to get this done.
Shouldn't we be reading paragraph 55 liberally? To be saying that the proposed development wouldn't have been approved could have been approved without relocating the substation?
I think that's more than a liberal reading. I think that's a reading that I'm not sure they could have alleged that in good faith. I don't think there is a basis to say that.
But let's say we can read it that way. Would we then have to turn to the public record?
I think I'd first have the argument that even that kind of assertion is not sufficient under Yannickino. I think that's a conclusory legal assertion, even as reframed by Your Honor. You would need to have some kind of factual basis for it. But then, yes, the public, not just the public record, I think Exhibit C and Exhibit E to the complaint also show that these were conditions that were necessary for the
on the
city's
existence of a fiduciary duty, it is true that in the motion to dismiss itself, maybe you not personally, but your client argued that it requires factual development. So that's not properly before us, right?
I agree that we said that. It is properly before you in the sense that as appellee, we can urge affirmance on any grounds supported by the record.
That's right, but that your opponent is correct that they could have amended the complaint.
I don't think they could.
Right?
Well,
because no answer was filed.
No, I don't think they could have amended the complaint. I don't think they have stated, either in their briefing or this morning, what non-conclusory allegation they could have added that would have solved the problem.
I thought it had to do with mutual assent.
Well, merely saying mutual assent is, again, a legal conclusion. Now, if they could allege, and I don't think they can in good faith, but if they could allege a representative from the trust said to a representative from Alexandria, we are reposing trust and confidence in you to maximize our additional purchase price, then that would be a sufficient
Maybe
allegation.
they could have said that.
I beg your pardon?
Maybe they could have said that. We don't know because they didn't know they had to amend the complaint.
They have not suggested in their briefing, in either their opening brief, in their reply brief when they were on notice that we were pressing this argument, or this morning, that that could be alleged. If that was true, if a representative of the trust had said, sitting across a negotiating table with the trust represented by Brown Rudnick and Alexandria represented by its lawyers, and the trust had said, by the way, even though we're negotiating this 67-page purchase and sale agreement, we are reposing trust and confidence in you to maximize our additional purchase price, you can bet that would have been in the complaint, and it would certainly have been mentioned.
It does feel a little bit like a gotcha to affirmatively say something requires factual development and then argue the opposite on appeal.
Well, in that case, Your Honor, we think you can perfectly resolve this the way Judge Barry Smith did, which is there is no plausible allegation of breach or of harm. Because even assuming there was some kind of fiduciary duty here to get an additional purchase price, if at all possible, there is no plausible non-conclusory allegation that it was possible. The trust seems to be arguing that we should have rejected the city's demands and and simply said, we're not going to pay more than $55 million. And in that situation, the attachments to the complaint, reinforced by the public record, but not necessary to look at it, the attachments to the complaint show this would not have been approved. There would have been no added density. There would have been no additional purchase price at any rate. We'd respectfully submit, unless there are further questions, that the court affirm the judgment of the Superior Court and award us our appellate fees under Section 47 of the agreement.
Hearing none, thank you so much.
Thank you, Your Honor.
Difficult case, well argued. The next matter on our list, 2023P0308, DONNA BUCCA versus Commonwealth of Massachusetts. So attorney, not sure how to pronounce the name, so Gary, how do you pronounce it? Algieri. Thank you.
Right. May it please the court. Attorney Anthony Algieri for the DONNA BUCCA, individually and on behalf of all others similarly situated. We are here to appeal the motion to dismiss that was entered by the Essex County Superior Court of an amended complaint in which she sought the enforcement of the requirements of the Wage Act against the Commonwealth of Massachusetts. The trial court, as the record shows, relied chiefly on this court's decision of Donahue in 2021 for the proposition that although the Commonwealth is mentioned 2 or 3 times expressly within the Act, sovereign immunity applies and therefore shields it from the basic requirements of when to pay wages to employees. Ms. BUCCA asserts that Donahue is factually distinct and substantively flawed, and
Barring some exception, the Commonwealth can't sue the Commonwealth, right? Barring some exception, the government can't sue itself.
well, it can be subject to sovereign immunity, exceptions to sovereign immunity in 3 different instances, and that's what Ms. BUCCA asserts. Number 1, the legislature spoke in 1978 and enacted the Chapter 258, which, although it's called the Tort Claims Act, covers much more. And as the record before you cites to, it covers all public employers shall be liable for injury or loss of property or personal injury or death caused by negligent or wrongful act of any public employee while acting in the scope of their employment. It is
Has that statute ever been read to apply to anything other than tort claims?
To my knowledge, Your Honor, no.
Okay.
But I'm suggesting the wide reading of that, and that's the
I mean, wouldn't it
legislative intent.
essentially abrogate sovereign immunity in almost any context if you can read wrongful that broadly?
For loss, for
Right, but I
responsible
mean,
for loss of property.
It
What
would
we're saying is
essentially
property
abrogate
is
sovereign immunity anytime someone alleges.
particular instance, which is loss of property for wrongful acts or omissions. We'd submit that the payment of earned wages are a loss of property, subject only to a $100,000 cap. The trial court agreed with that questioning, Your Honor. So we would suggest if it simply applies to torts and that this is not a tort, but rather a contract, the Supreme Judicial Court, 9 years after the enactment of the Tort Claims Act, ruled with Minton Construction Court versus Commonwealth. And it expressly said, and I'll quote the opinion, it held, quote, "The Commonwealth long ago waived its sovereign immunity against actions brought to enforce obligations it assumed through contracts. Further, as a result, the Commonwealth will be answerable, quote, exactly as though it were a private individual," citing to the Nash case from the 1800s.
And the Commonwealth hasn't argued that the breach of contract claim could be dismissed on sovereign immunity. That was the basis of a separate argument, the failure to exhaust the grievance process. So it's
Correct.
true, the Commonwealth can be sued in contract, we all know that.
Absolutely.
But we're talking about the Wage Act claim, not a contract claim.
It assumed the role of employer by contract.
Right, and it can be
further-
sued under an employment contract, but you're trying to sue under the Wage Act. So we need to find a specific abrogation of sovereign immunity in the Wage Act. So where is that? And how do
that
you
is
get
a-
around Donahue?
It's not in Donahue, and if you believe that Minton Construction does not control as an exception to tort to contract law, we look to the statute itself, the Wage Act. And the Wage Act itself commands only two things: when to pay employees after the pay period has been exhausted, which is either weekly, biweekly, or monthly, and I'll get to the Donahue decision, which can be otherwise if requested in writing, or when they are paid their wages upon termination. As the Supreme Judicial Court just decided last year, when it's a termination for an employer termination, they must be paid on the day of the termination. When it's voluntary, such as here, a retirement, I quit, it has to be by the next regular pay period. And what I would suggest that in fact, it's actually in the Harrison case that talks about how you examine whether there is a waiver of sovereign immunity. And on page 7 of that decision, it states that the rules of construction governing statutory waivers of sovereign immunity are stringent. However, even strict interpretation must be reasonable. A sovereign immunity analysis ultimately turns on legislative intent. What is legislative intent? The statutory language, quote, is the primary source of insight into legislative intent. We turn back to the Wage Act itself. On the second page, no person by special contract with an employee or by any other means except for himself may exempt himself from this section, meaning the entirety of Section 148, or from Section 150, period. It says who that person is for an employer for a corporation in the next sentence, and then it turns to the public. Every public officer whose duty it is to pay money, approve, audit, or verify payrolls, or perform any other official act relative to the payment of any public employee shall be deemed the employer of such employees and shall be responsible under this section for any failure to perform his official duty relative to the payment of their, meaning any public employees, wages or salaries, unless prevented from doing so through no fault on his.
Why isn't it simply identifying the individual within the agency who's responsible for compliance with the Wage Act? Just as the previous sentence identifies the president and treasurer of a corporation and the officers or agents having the management of such corporation, they're deemed to be the employers of the employees of the corporation.
This is saying that every public employee is the public officer, whoever that is. Certain departments are
I mean,
going to
if
have
that
one
reading
person.
is correct, then the initial paragraph that confines the subset of employees to mechanics, laborers, and forget the third.
I'm glad you raised that.
workmen and people employed by penal or charitable institutions, that would be completely superfluous then.
It's not. It
Why?
only deals with the first part of the requirement of the Wage Act. What is the pay period? The Wage Act requires payment of the pay period within 7 days maximum. It also talks about 5 days and 6 days in certain circumstances. It talks about laborers, workmen, mechanics, and those that work in penal or charitable organizations, that they may request a different pay period in writing. That's all that talks about, because if you look earlier in Chapter 149, and I would turn your attention to Section 42, and there is Section 30 that talks about laborers, workers, mechanics, foremen, Section 31, but 42 says all laborers, workmen, mechanics employed by the Commonwealth or any officer, department, board, or commission shall be on a day work basis. So I think it's talking about employees that have a very different work week than your typical 9 to 5. These are people that, it defines, for instance, if you can bear with me a moment, that laborers in Section 32 of 149, laborers, workmen, and mechanics shall be deemed to include engineers and janitors, custodians, and other employees doing similar work in schools, in public buildings. And if they're day laborers, that means that they're working the graveyard shift, they're working overnight, they're repairing the railroad tracks before the commuters come in. And by saying that they're day laborers, that is including them within the ambit of the Wage Act, but reflecting that they were previously determined to be paid daily, which the Wage Act doesn't contemplate. So there, for whatever reason, the legislature spent a great deal of time defining those people earlier in Chapter 149. But we would submit that you have to read, Donna, you stopped at the section you just cited to, Your Honor. It didn't read the rest of the statute, and we would suggest that statutory interpretation, you must do that. You have to read the whole act, and when you read the whole act, that's the more broad command. No one can, by a special contract, which is almost speaking to the state, because it's got scores of collective bargaining agreements, like the one that was appended in this case. It's dealing with contractual relationships with its employees. That thing's over 150 pages. It didn't stop there. There were memorandums of understanding. And as to your earlier question, Your Honor, about, well, what about grievances? Nowhere in all of those pages or memorandum of understanding does it command or promise when payment of wages are made. It's completely silent. So how can you grieve something that is not contemplated by that agreement? The answer points to the record. I believe it's Record Appendix 200 and 201. The Commonwealth knows it's subject to the Wage Act. It issued a memo from the comptroller that's responsible for all of the agencies of the Commonwealth that said, you've got to pay within 2 weeks, citing and pursuant to the Massachusetts Wage Act. It was amended 3 years after, from 2004 to 2007, I believe. So it fully contemplates that it's subject to the Wage Act. And again, it's only the very basic thing of when payment is made.
So have you abandoned the breach of contract claim? I don't see much in your brief about breach of contract.
The breach of contract has it abandoned? No, I'd want to keep all my arguments available, Your Honor.
I don't see anything.
But
maybe we'll determine.
There's no doubt. It is essentially, it is an analog to the citation to Reuter versus the City of Methuen, where Justice Georges, in his concurring opinion, said that you should not be limited in the damages under the Wage Act simply to the wages themselves. That Section 150 talks about wages and other benefits, and his concurring opinion also talked about consequential damages. So from that standpoint, where there was a contractual benefit expressly conferred to employees, and again, it doesn't say when they're paid this, but it did say they get 20% of their earned sick time paid for when they retire, but when? And we would suggest that when it's silent, that you would defer to the basic tenets of wage law in the Commonwealth. Because to do otherwise is to exclude probably the largest employer in the state. I believe the record submitted shows that In September of 2022, there were 148,000 employees in the Commonwealth. You know, this is not, you know, if you look to the sovereign can do no wrong and the traditional tenets of sovereign immunity, there's no worry that this is going to, you know, bankrupt the Commonwealth. You know, the governor just submitted a $56 billion budget. In fact, last tax year, they had to return billions of dollars to the taxpayers because they had collected so much money. You know, this is not we got to protect the Treasury. That's not the case here. It's, if you look at it by way of it is included under Chapter 258. We believe that language is expansive enough to be included, subject to the $100,000 limit. If not, and you say, nope, it's a contract law by the Supreme Judicial Court says they're answerable like any other individual. That's been since the 1899 case of Nash. If you say no, it's traditional tenets of sovereign immunity analysis, even that results in the finding that the clear, unambiguous language of the act itself is the expression of the legislative intent, and they clearly name the Commonwealth as being included. They clearly name public employees as being included and protected under those protections, under the Wage Act. Excuse me. So in sum, we believe on all three of those counts that the trial court erred as a matter of law, that the decision should be reversed. The Commonwealth admitted in its brief that it didn't pay Ms. BUCCA, and we suspect all others similarly situated by the next regular payday, because wages are express in the Wage Act, which is one of the factual distinctions of Donahue. Donahue involved merely compensatory time. There is no case law, and it's not within the act itself that compensatory time is covered. And as to sovereign immunity, it applied the New Hampshire Insurance Guarantee Association case, and that dealt with the federal sovereign immunity. You know, this suit seeks a declaration as to the agency of the federal government should go about its business enforcing federal statutory scheme. You know, common sense requires the conclusion that such supervisory adjudication does not belong in state court. And then it quotes, sovereign immunity is an ancient doctrine which applies with full rigor today.
See,
it was a
that's
cut
your
and
time.
paste. And with that, we would, unless there's other questions, we'll rely on the brief and the submission. Thank you.
Hearing none, thank you. Attorney Sento.
May it please the court, Patrick Sento, Assistant Attorney General, on behalf of the Commonwealth, the appellee in this matter. The Superior Court correctly determined that Ms. BUCCA's Wage Act claim was barred by sovereign immunity. This is the only reasonable result based on the clear language of Section 148. Diving first into Donahue, the Superior Court correctly recognized that Donahue here is on all fours. And Ms. BUCCA's attempt to distinguish it is misplaced. The two arguments she makes to distinguish it, I'll address them one in turn. The first is the argument that because it references or cites to the New Hampshire guarantee case, that case is somehow on a different base. That case is cited exactly once in Donahue, and for the very basic proposition that sovereign immunity still exists. So it wasn't a chief, the Donahue decision didn't rely on that case in chief, it was a passing reference. And the other argument Ms. BUCCA makes to distinguish Donahue, that Donahue dealt with compensatory time as opposed to vacation, accrued vacation leave, is simply inapposite. There's nothing about the nature of the compensation at issue in Donahue that changes its fundamental holding, which is the scope of the limited waiver in Section 48, specifically who falls into within the terms of mechanic, workman, and laborer. So Donahue is on all fours, and we would argue controls here. my brother referenced the Harrison decision, which is more recent than Donahue. The Harrison decision is incredibly important for this case because the arguments that the court confronted in Harrison were the same arguments that Ms. BUCCA is making now. That is, that there are certain public policy considerations that can somehow serve as a substitute for clear statutory language with respect to waiver. And the court in Harrison rightly rejected that argument, saying that the general principle that remedial labor statutes should be construed liberally must give way to the more specific rule of statutory construction that purported waivers of sovereign immunity must be construed stringently.
So I didn't see in your brief where you specifically addressed your opponent's reliance on this sentence, every public officer whose duty it is to pay money shall be deemed an employer. Do you have any comment about that?
I absolutely do. Thank you. So that there is clear case law explaining that provision of Section 148 confers or establishes individual liability under Section 148. But there is no controlling case law that says that language expands the scope of substantive rights under 148. Because it doesn't expand the scope of who falls within the purview of the Wage Act and who the Wage Act applies to, it's simply that language does not apply to Ms. BUCCA here.
Appellate cases you're referring to? Are they cited in your brief?
They aren't. However, I'm happy to. I could name one or two here. Specifically, I believe it's the Paris decision, where
What's the site?
it is not the Paris decision. I apologize. It's Cook versus Patient Education LLC, 465 Mass 548, explaining that language of Section 148 imposes individual liability. But I am not aware of any appellate case law explaining that or holding that language expands the rights or expands the scope of who the Wage Act applies to. We
shouldn't hold that way because?
I'm sorry, could you repeat that?
There's no case that says it, and we should not say it because?
This court should not hold so because, first of all, Ms. BUCCA is not asserting a claim of any individual liability. She's not attempting to.
Why can't it be read to expand the classes of public employees that are subject to the Wage Act?
Well, I think it goes back to the basic principles of sovereign immunity and the purpose of sovereign immunity, which is to limit the public fisc from unanticipated money judgments. And the languages of which Commonwealth employees have rights under the Wage Act is crystal clear, and that language is what controls here. The other thing I really want to hit on with Harrison is that Harrison addressed the related public policy argument that was made both in Harrison and in this case, that somehow the size of the Commonwealth's workforce mandates that this court infer or find some kind of implied waiver. But the size of the Commonwealth's workforce, and especially in the context of Section 148, cuts in the opposite direction. If the legislature was going to open itself up to liability for treble damages under Section 148, under a strict liability statutory scheme to all Commonwealth employees, it would have done so in explicit language. It's much more reasonable to assume that the legislature meant what it said in Section 148, which is that a limited subclass or subset of Commonwealth employees can bring suit to vindicate rights under Section 148, or has rights under 148 that can be vindicated under the private right of action in Section 150. So the scope of the Commonwealth's workforce combined with the remedial nature of the Wage Act, those two things combined cannot act as a substitute for clear legislative waiver of sovereign immunity, which is what Harrison said. I would also like to briefly address some of my brother's additional arguments as to where waiver may be found. With respect to Chapter 258, as the court hinted at in its questions previously, the Commonwealth is aware of no controlling case law where 258 has been read to expand liability outside of a traditional common law tort liability. And to the extent that Ms. BUCCA is attempting to frame this as some kind of a tort claim, it would be a claim for conversion, which is an intentional tort for which the Commonwealth explicitly retained its immunity under Section 10 of the Mass Tort Claims Act. So that the argument that Chapter 258 somehow acts to waive sovereign immunity under the Wage Act is just respectfully incorrect and without merit. The argument that the Commonwealth somehow waived its sovereign immunity by entering into the CBA with Ms. BUCCA's union is similarly incorrect. Sovereign immunity can only be waived by the legislature through clear language. The act of an executive branch agency executing a collective bargaining agreement simply can't do that work. And then the other thing with respect to, or the other argument that my brother makes with respect to special contracts and that provision in Section 148, that somehow if we don't read a complete waiver of the Commonwealth's sovereign immunity into Section 148, there might be a conflict with the rights conferred under the CBA. And that's not correct for two reasons. The first is because Ms. BUCCA is not and does not allege to have been a laborer, mechanic, or workman, or to have worked in a penal or charitable institution. Again, she simply has no rights under the Wage Act. That's not to say that she doesn't have any rights. They're just simply not conferred by the Wage Act. Her rights are conferred exclusively through her collective bargaining agreement. Now, because she doesn't have any rights under the Wage Act, there can be no conflict between what her rights are under her CBA and anything she's owed under the Wage Act, because, respectfully, she's not owed anything under the Wage Act. And the idea that the CBA, if I'm understanding my brother's argument correctly, is an improper or an impermissible special contract if we don't find waiver in Section 148, is incorrect simply because the language of Section 148 states that public employees, the subset of public employees that the Wage Act applies to, can request in writing to be paid under a different payment arrangement. And it's long been held that, unlike private employees, public employees have this additional right or ability under Section 148. So even if Ms. BUCCA did fall within the purview of the Wage Act, and even if she was a mechanic, a laborer, or a workman, or somebody employed in a penal or charitable institution, she could still request and agree upon a different payment schedule through the CBA, which is what happens all the time. That's why CBAs themselves are valid and they're not impermissible contracts, because the vast majority of Commonwealth employees can do that, and even if they're in the limited subset under Section 148, that's provided for in the statute. And so if there aren't any further questions, I'm happy to rest on the papers, and the Commonwealth respectfully requests that the court affirm the Superior Court's dismissal of Ms. BUCCA's amended complaint.
Thank you kindly.
Thank you.
Matter stands submitted. Our final matter for the day is docket 2023 P0325, Vineyard Conservation Society versus Tanya, DEVINE, and others. And we will hear first from Attorney Willis. Okay.
Who's the appellant?
Attorney Poloni. Poloni, got it.
Good afternoon. May it please the court. Jonathan Poloni on behalf of the appellants, who are several of the named defendants and heirs of the principal party, Louisa E. DEVINE. I want to just bring the court's attention, I think, to a primary matter, which is going all the way back to 1870 and the establishment of the Massachusetts Indian Enfranchisement Act, which was passed in 1870 and led to the allotment of the common lands of the Gayhead Indians to individuals. And the lot that we're concerned about here was one of those pieces of land. And it was set off to Louisa E. DEVINE. And because of that singular act, is kind of leading to the circumstances which brings us here today. The court, in its decision, found that parallel evidence was not admissible. And I think that was the first
Well, I don't know
mistake.
that they found it wasn't admissible. They found that they didn't need to turn to parole evidence because the language was clear and unambiguous. And it seems to be your argument that they should have looked to extrinsic evidence notwithstanding.
I think that's right. I think my read of the case is that she did try to exclude evidence in the first argument and then kind of went beyond that to say, well, even if I were to consider this additional evidence, it wouldn't change my
You
reasoning.
did say that.
But I think that even if you view the language of the particular deed in 1945 and view that as unambiguous, it still begs the question of what is it referring to? There is a need to look outside of that one deed to find out.
Doesn't any and all mean any and all? I mean, the plain
It
language we look
does-
to first.
It does mean that, but I think it means that in the context of what that meant in 1945.
Even had they not known that they owned it, they can still give it away if they own it, right? Any and all. So I didn't realize I own this piece of property, but I do, and that falls under the umbrella of any and all. I'm trying to get rid of any and all property that I have.
And I think that's what's really unique about this case, is that where that broad language would cover even land that the grantor didn't know he owned, in this case, it was land that he knew somebody else owned. He knew somebody else had a claim to this land because it was in a deed to somebody else. In 1945, the Cape Cod Company had a deed from Ralph Hornblower that contained Lot 240 in a specific description. It had a meets and bounds description. This is found in the record in Exhibit 18, Record Appendix 2, page 110. On page 110, it shows the specifically, references specifically the deed from Francis Mayhew. It calls out Lot 240, and it gives the meets and bound description describing the original set-off to Louisa DEVINE. That is the situation that's confronted in 1945 that makes this situation unique and different from just not knowing what
Maybe
you
he
own.
knew that that was invalid. I mean, how do we know that?
I think that is giving a little too much benefit of the doubt. If there was one party who had real knowledge of this case, I think it really would have been Henry Kronig, the grantee. He had a lot of dealings, we know, with both Cape Cod Company as well as his own company, Lagoon Development, that had a dealing with various properties. But I think that requires, it puts a burden on the grantor to understand what happened in 1870 that he might not really have known. Or that he didn't know.
So going back to Justice Desmond's question, why couldn't, is it Horace? There's so many names in this case.
Horace, yes, Horace DEVINE.
Why couldn't Horace have just decided, I don't want to own any land. I don't care if I know about it. I don't care if anyone has a claim to it. I don't want it. Therefore, I convey all and every piece of land that I own.
And I think I'm trying to parse this and be clear also with what I'm saying,
Yeah.
because I think you can't get around this looking at the deed interpretation, which requires looking at the grantor's intent. And my position
Hold on.
basically,
Let's stop there. Why? Why does it require looking at the grantor's intent beyond the plain language of what the grantor says?
because the intent and circumstances apply. The cases that I cite to in my brief, Sheffield, LaBelle, and also the Erickson v. Ames case, describe similar circumstances. The Erickson and Ames case talks about an easement, and it's interpreting the language there, but it relied on the extrinsic evidence in order to understand what circumstances attended to that time. Even the Finbo case...
I'm not saying that it's impermissible to do that, but what case says it's required to do that? What's your best case for that? That you must look to extrinsic evidence?
I think that it's all the cases cited by both myself and my brother. I don't think there's a conflict in those cases. The peril evidence is evidence of the circumstances at the time. And in order to because you're trying to understand what the grantors intended. I would agree with you that Horace intended to give up his interest in Gay Head. But it doesn't apply to Lot 240 because he objectively believed somebody else had a claim to that land. And it's not a minuscule piece of land.
Does it change anything that, let's say he was mistaken? Does it mistaken about, is that any different than not knowing what land you actually have?
I think it's diametrically opposite of not knowing. It's not, he didn't not know. He knew. He knew that somebody else had a claim to that land because the family conveyed it out. Did he know that that was an improper conveyance? I think requires a level of legal expertise that he did not have and nobody in the family had. And it's also looking at the subjective intent, that would be improper. And I'm not suggesting you should try and understand how Horace was feeling at a particular time. But I think that's why it's important to look at the surrounding circumstances, because objectively, what Horace could have granted in 1945 did not include Lot 240. And this is a hard proposition because I don't think you want to just see a piece of property falling through the cracks the way that I'm suggesting it has. But the proper path is for it to remain with the divine heirs. I think that that's perfectly acceptable, especially in this circumstance where you're dealing with people who have been dispossessed by the land in Martha's Vineyard for such a long time.
If it wasn't, I think it was Eliza. If it wasn't hers to give away, how can she give it away? Right? She's the daughter of Louisa, right?
Yes.
She's the one who believed that she owned it, but she didn't. So you can't give away something that you never owned. So what difference does it make whoever received it? She didn't have, it wasn't rightfully hers to give away. So I don't know what more do we need to look to? Do you dispute that?
Well, what I feel is important is that the decision on that was not made until 2022. It wasn't until the plaintiffs brought this before the court in their petition, and it was fleshed out that there was this problem with the original grant in 1887 to Francis Mayhew. And it wasn't until 2022 when an actual challenge to that deed was made. So all through the record, from exhibits 20 to 25, from the Cape Cod Company and Hammond before that and Hornblower, down to the Vineyard Conservation Society itself, the named plaintiffs, they all have title to Lot 240 expressly written into their deeds. It's an odd twist of fate that those deeds are invalid, but I don't think that invalidates the grantor's intent in 1945 because of that fact. I think it's an integral part of what happened, and it's an entirely unique and odd situation. I don't think that there's any precedent for it, but I think that the cases that are cited in my brief support the fact that peril evidence does come into play, should be considered. It's not to be excluded unless it's repugnant to the text of the document itself. And that brings me back to this argument that it's reasonable to consider this other evidence because it doesn't conflict with the interpretation of what he knew in 1945.
Doesn't it conflict if the language if the language is, I give everything, I give all, and to read into it, I give all except, it sounds like that it would be repugnant to the plain reading.
I think it appears that way when you're looking at the circumstances that we know now in the present day. And what I'm just trying to suggest is that you need to look, the appropriate place for departure is the date of the grant. The date Horace signed the deed in 1945 and what the circumstances were at that time. It's not, as my brother has proposed, a question of all the land that I know I have an interest in. I think that the phrasing is all the land that I have an interest in 1945. And it's the court interpreting now in 2022 what the state of title ownership was.
Did
That
Louisa,
did not happen in 1945.
did Louisa have any more interest in Lot 240 in 1945 than she would today?
So Eliza granted her interest to her nephew Horace in a deed, I believe it was in 1937. The important thing there is that that deed used the same language that Horace later used in a 1940 deed. It was kind of a common thing to say, and I'm giving away all the land that I own.
I think Judge Sanders points out 6 instances in this change. That language
There,
is used.
well, from the Horace deed on, Henry Croning adopted that same language to say, in any land that I may own in Gay Head. And I think that was the 6th change that she was referring to. But there were the deeds before that from Eliza to Horace and also from Horace's siblings to himself, consolidating their interests in multiple properties that had been taken for taxes. I think that all of those deeds suffer from the same defect because at all those times, Lot 240 was claimed by another individual. That is all the evidence that is made up.
So
in the
how do you
May
respond to your opponent's argument that in the probate of
Joseph Lang.
Joseph Lang's estate, that the inventory lists Lot 240, and this was after the conveyance, the purported conveyance to Mayhew?
So it's interesting. I've spent a lot of time staring at all of these documents. When I was looking at the estate of Joseph Lang the other night, this is Record Appendix 3, page 7, and it's also Exhibit 28. When you look at the actual document, the inventory for the real property, what it is it's a list of property that made up the Patrick Devine estate. That was his father. That was, I believe, Joseph Lang's grandfather. It lists the Patrick Devine estate, and then it lists all the lots associated with that. It doesn't list any values, which I think is notable. It lists property size. It lists all the acreage of all these different properties. Below that, it lists the estate of Simon Johnson, who was his brother, Simon Devine, who predeceased him. And then at the bottom of that, it says the amount of share belonging to Joseph Lang. And at that bottom level of the page, it actually lists the dollar value for each of the lots that he could claim an interest to or that were reported on the inventory. Lot 240 doesn't appear in that section that's applicable to Joseph Lang. And that is consistent with all of the other probates that do not include Lot 240, including the estate of Estelle Capel, the final kind of grantee on the Devine Croning chain. She conveyed to her 3 siblings, or her estate passed to her 3 children, and they are the ones who then conveyed to the Vineyard Conservation Society this alternate deed purporting to claim Lot 240 and pass it on to the Vineyard Conservation Society. The estate of Estelle Capel, which is Exhibit 41 and Record Appendix 6, page 5, does not include a reference to Lot 240. So even Henry Cronig, who accepted the property from Horace in 1945, passed it through these general grants, it passed on to Estelle Capel. Her probate, again, is devoid of Lot 240. My one final point is with reference to Lot 276. Lot 276 was discussed in the judgment. It was discussed at trial. Lot 276, I would suggest, is evidence that Henry Cronig and Horace could have corrected the record had they wanted to. If they wanted to make an express conveyance of Lot 240, they could have done that, and that's what Lot 276 means. That deed came in 1947. It was a conveyance from Horace Devine to Henry Kronig, similar to the prior deed, but it was a specific conveyance. Knowing
That lot was conveyed again, right, immediately thereafter?
And then he conveyed it to
So
Lagoon
isn't that
Development.
the possible purpose for that specific deed?
was to eliminate any doubt.
Right.
And if they
right.
wanted to eliminate any
If it
doubt.
was needed because they were planning a conveyance, but nobody was conveying Lot 240 separately.
Correct, but it is evidence that he could have, had he known or had he considered that he was an owner of Lot 240, he could have had Horace convey that
Yeah,
specifically.
but I mean, I don't know how you take from that he didn't know that he owned it. But I understand the argument.
Thank you. So I will rest on that, and again, I am requesting that you reverse the lower court and find that this property properly belongs with the heirs of Louisa Devine.
Thank you. Attorney Willis.
May it please the court, John Willis on behalf of Vineyard Conservation Society. So
Our standard review is de novo, is that correct?
it's de novo as to the determination that the language in the deeds is unambiguous. And I would say that it's clearly erroneous as to the factual findings if the deeds were ambiguous, the effect of extrinsic evidence. And I do have that cite in my brief. So this really amounts to speculation as to what Horace Devine knew in 1945. We don't know what he knew, and there's evidence in both ways, and it shouldn't get in because the 6 deeds at issue here with that language are unambiguous. They say all my land in Gayhead. And there's clear controlling precedent. The Campbell case and SJC case and the Hadley case, appeals court case, the Flinville case, land court case. And every time this language has come up, the courts have enforced it and said that it means what it says, all my land in the geographic district. Now, as to the Lang probate in particular, it does list 240, lot 240, and down below it says the amounts of different types of land, and it's got 1/4 of all the beach land valued at $6 per acre, 24 acres. And I think if you add up the beach land, that this was lumped in. It says comland, but I think it was lumped in. So I think it was included in the valuation. That they thought, that Horace Devine thought that Joseph Lang owned 1/4 of it at that time.
So when you have that language that you give all and everything, does it, your brother is arguing about you. When you interpret that, you need to know what the grantor knew. Do you agree with that?
No, Your Honor, I don't agree with that. I think it's unambiguous, all my land in Gayhead. It just means that. You don't need to go beyond those words to determine what the grantor knew at that time, because the language is plain. And so I think all the cases that I cite, all the cases that he cites, have in common that if the language is unambiguous, then you don't go beyond the language of the deed. And
But you're supposed to be interpreting the grantor's intent in every situation. Correct?
yes, Your Honor.
And if the grantor was mistaken, then you're not properly interpreting the grantor's intent.
I'm thinking about that for a moment. That's true, I think, because and that's what the law is. You just look at what the deed says, if it's unambiguous. But there is a remedy for that. If the grantor made a mistake, the remedy is an action for reformation, which was not pled in this case. And there has to be clear and unmistakable evidence. The burden of proof is on the party seeking reformation. So if a grantor makes a mistake, they can fix the deed or try to fix the deed based on reformation. But there's no attempt to do that here. And there isn't clear and unequivocal evidence that there was a mistake. It was very plain language, and it showed what he wanted to convey, everything he owned in Gayhead, as Desmond said. And so I think it is repugnant to the text to say everything, that the deeds convey everything I own in Gayhead except for lot 240. It doesn't make sense. It's contradicting the plain, unambiguous language.
At some point, don't they say they grant everything except the homestead? Is that one of the deeds?
I believe it is one of the deeds, yes.
And so how would you accept it if you didn't know that you owned it?
I suppose if you want to accept land that you don't know that you own, then it should be phrased the specific things that you know you own. And you shouldn't say all land I own in Gayhead, because that by definition includes whether you know about it or don't. Yeah, I mean, that catch-all clause, I think the purpose of that is to include something that you might own. You're not really sure. Maybe you've forgotten. In this case, probably or possibly, I can speculate that Horace Devine knew that his aunt had signed the 1887 deed and that it wasn't his grandmother who signed it because she had died. But he might not have known if he really owned it or not. And there's chain of title going to Cape Cod Company, so he didn't really need to say lot 240 in it, but there's this question mark he's got about it, so I'm giving everything. I don't want to deal with the question mark. I don't want to deal with the litigation. I've got enough problem paying the taxes on the property. So it just makes sense. He lumped everything, and he got something in exchange from Henry Kronig. So it was, and we don't really, it's a recorded deed, so we can't really look, we don't know the amount of consideration. We have to assume that it was valid consideration, that he got a fair deal. And that's what he gave up.
Let me ask you another question, if I may. You say in your brief that your brother presumes or surmises that there was a tax taking to the property, but that's not really supported by the record. Did I understand that correctly?
I'm not sure. So there was no tax taken to lot 240.
There was not.
There was none. And I think the judge does say that in a footnote in her opinion. And I think the reason is that there's this chain of title. At that point, probably his Cape Cod Company was paying the taxes on it, so there's no taking as to it. And I think probably in this deed from Horace Devine to Henry Kronig, they just looked at all the properties that there are tax takings, and that made it easy. And then they said that then the deal was to add something more, not just that, add everything that there might be a claim to, and that's where lot 240 comes in. We can't just read that out of the deed. And let's see. I also want to point out Trial Exhibit 45 is the REBA title standards, which says that...
Sorry, I didn't hear you.
Trial Exhibit 45
No,
has the REBA title standards, Real Estate Bar Association. So there's one, number 36, which says that the omission of property in a probate doesn't affect title. It's still good title. And I want to point out, I don't have the exhibit number right now, but in the will of Estelle Capel, it gives residuary of her estate, the real estate, to her children. So it's very specific about that. It doesn't specifically mention lot 240, but it may not specifically mention other lots either. So it's similar to this catch-all phrase, everything goes to her children. And I think to answer Justice Singh's question, Eliza doesn't have any more interest now than she would have had in 1945. it hasn't changed. And in the Finbo case, I wanted to point out, I disagreed with my brother's reply memo as to whether it allowed extrinsic evidence. I think it was very clear that the court did not consider extrinsic evidence. It said the parole rule applies because the phrase, all our land in Negro Town, was unambiguous. And also disagree on whether the court discussed the tax takings. It did discuss that in footnote 5. And so, so I think the bottom line here is that the deed is clear and unambiguous, and so parole evidence can't come in.
Well, your brother actually takes issue with that, saying even if it's unambiguous.
Even if it's unambiguous, then still there's really no evidence here that would justify changing the clear words in the deeds. Thank you.
Thank you. Matter stands submitted. That concludes our business for the day. Court will be in